Moving on to the second top 10 risk, I'm going to talk about sports and recreational activities. And in this particular section, I like to subtitle this, all the things that your youth pastor is trying to drag the church into, i.e. any sort of extreme sports, skateboard parks, rappelling down mountains, usually playing with fireworks. Whatever happens to be the flavor of the day, youth pastors are full of lots of energy and enthusiasm. They want to bring kids into the church. And really in the marketplace today, they're competing against other organizations and other churches to bring kids into your church, into your programs. And so, in a way, when you think about sports and recreation, we're not talking about traditional, church baseball games. We're not talking about, what happens at a church picnic. We are talking about programs that are set up. They could be summer VBS programs, they could be regular youth nights through the week, they could be retreats, wilderness tours, all kinds of different programs. And I would maybe at this point say as well that, and this is a direct comment to you as board members or trustees, that when these ideas are brought forward, your responsibility and your fiduciary duty is not necessarily to say yes all the time. Sometimes it's to say no. And the criteria that you really need to use when you're thinking about these proposals or these ideas is simply this. Do you have the resources, the equipment, the money, the personnel, the experience to run the particular program that's being proposed? If you do, then it's probably the right choice for your church. But if you're simply doing it because everybody else is doing it, I'm going to suggest to you that probably at the end of the day, you may not be doing it first rate. And that puts you in a difficult position because you're trying to run a program without enough money, perhaps with used materials, and not having the right supervision. And the bottom line is those are exactly the circumstances where claims that are foreseeable and preventable can occur. And in those cases, it's probably best to either take your kids to a commercial facility where they have the supervision and they have the liability insurance, or to work with other churches in the community and have your kids go into their programmings where they can provide these services and provide these programs for kids. The sad thing is that sometimes churches do get involved in programs and events where there is a really bad outcome, where there is an injury, paralysis, permanent and serious injuries, fatalities, and where the program wasn't run properly. And now the church is the object of a lawsuit. The directors are sued personally. Liability suits can take years to go through the courts and draw the focus away from your ministries and activities. So as a church, you really need to decide, is the proposed activity really core to our ministry? Is it a part of our vision? Is it who we are? And are we so committed to it that we do have the resources and the experience to run this properly? Now, organizations that are at greatest risk for sports and recreation exposures would certainly be any churches, schools, campgrounds, youth associations, organizations that conduct sports programs, special events, leagues, training camps, exhibitions, wilderness programs. And at particular risk are those organizations that sponsor high-risk or extreme sports, everything from skateboarding, water skiing, rock climbing, whitewater rafting, canoeing, wilderness tours, contact sports, paintball, you name it, just go down the list. Okay? They're fun activities, but again, they do put you at an extremely heightened level of risk. Individuals at risk, obviously any minors or even adult participants in these programs. And potential sources of coverage, again, to relate it back to the first section of this presentation, because these are bodily injuries primarily, this goes back again to your general liability coverage. And again, also good to highlight the fact that because you can have multiple participants and injuries, it reinforces the reason why you want to carry or maximize your general liability limits as much as possible. One other thing I'll mention as well is that sometimes these injuries don't always automatically become a liability suit, particularly if the injury is something that is not permanent. And I should mention that in most insurance policies, and certainly in our Church Protection Plus plan, we have a very generous limit of $20,000 for what's called medical payments. It's a form of coverage that's available as directed by the board. So it's the board that decides whether this coverage is extended, but it can be given or extended to individuals who suffer injuries. They don't want to sue the church, but perhaps they have out-of-pocket medical or dental expenses. Maybe provincial hospitalization pays for part of those expenses or some not at all. This can supplement those kinds of sources of coverage so that the person walks away with no expenses out of pocket. And again, that's called a medical payments rider. In reviewing sports and recreation from an insurance standpoint in general, and again, I have to make a distinction between what we do and what the rest of the industry does, but it always surprises me that we'll get a campground that asks for a quote for their insurance, and in reviewing their policy, we'll find all kinds of exclusions, like things like abuse and so forth. But one of the amazing ones to me is a participant's exclusion, which basically states that if you're participating in a sports or recreational activity, there's no coverage. Now, this is a really big surprise usually to the camp administrator or the camp board members. And again, goes back to my point in the first section, don't assume anything about your liability coverage. You need to ask good questions. And certainly our scope of coverage is very broad, and we do have options available for many of these things. But again, regardless of who you're insured with, it's important to review these things from time to time and communicate well with our office or with your broker or agent. And this is a good way to avoid gaps in your coverage. Another thing I'll mention too is talking about sports and recreation. One of the questions that always comes up is with respect to releases and waiver forms. You know, are they worth the paper they're written on? Will they protect us? If we have a signed waiver or release, we don't really care about insurance. We don't have to worry about that because, you know, this will stand up in court. You know, that's our protection. The truth actually lies somewhere in the middle. And to give you a little bit of an explanation, generally speaking, a signed release or waiver on behalf of a minor, i.e. under the age of 18, signed by parents or guardians as a release of liability is probably not going to be enforceable in a court of law. You generally can't waive somebody else's rights to sue. And even if that child doesn't sue as a child, they can still sue as an adult. Okay, so one of the things to keep in mind with waivers and releases and liability shields is that when you're dealing with children, the more important thing to have signed is something called informed consent and permission. What that means is that you are sending something home to the parent, notifying them of the activity that the child is participating in or could be participating in, where it happens, when it happens, how they're going to get there transportation-wise. You know, we're going to a water park on the 28th of July, and we've chartered a bus. You state all of those things in the informed consent. You're communicating with the parent. You're getting their consent that it's okay for their child to participate. And then it's also a form of permission, but it's communication first and foremost. Now, does that form get you off the risk for liability? No, but it can make a huge difference in the event of an injury. And the way I usually explain this is that if you take your leadership hats off for a second and just think about yourself as a parent, and you send your child to, for example, let's say a summer day camp. You drop them off in the morning, you head off to work. As far as you know, your child is at that location. But you get a call partway through the day, and the call is from, say, the supervisor of the program, and they say, your son or daughter have been injured, they've broken their whatever, but it'll heal, they're okay, we're just at emergency. And it happened when we were at this water park. And you're going, what water park? What are you talking about? You didn't know they were there. And as a parent, your reaction, whether you're involved with a church or whether you're sending your kids to a church program from the outside, your natural reaction is you're really upset and bitter because you didn't know. The likelihood of suing in a case like that, even though the injuries are not that serious, is much higher. Compare that with a situation where they sent informed consent and permission home. They explained very clearly what the activity is, what the risks are. They got your consent. They maybe also asked permission to seek medical care if necessary, emergency medical care. They may have also surveyed your child for food allergies or medical conditions, but that's all been done up front. You drop them off in the morning, you get that call in the middle of the day, your son or daughter have been hurt, they're going to be okay. What's the difference in your attitude and your response? It's huge. You knew about it, you okayed it. The likelihood of suing is much, much less. So again, when we talk about waivers and releases with children, it's not really possible or enforceable legally, and informed consent and permission is what you really need from the parents. Now, with respect to adults, 18 years of age and older, it is possible to get their waiver or release of liability. May not always be enforceable in a court, but at least our courts allow for the possibility that somebody voluntarily assumes their own risk. They go skiing at a high altitude, you know, and that's part of your program. And you say, here are the risks. You're accepting responsibility. Well, to the degree that they were the authors of their own misfortune and caused their own accident, it's going to be hard for them to prove negligence against you. Okay, so with adults, it is still a worthwhile thing to collect a waiver or release of liability. And some of this information on things like liability shields, which these are, and other risk management aspects to Christian ministry, we do have quite an extensive collection of resource material available on our website. And if you go to www.robertsonhall.com and go into the Church Protection Plus section, there is a resources link, and a lot of this information is contained in articles, recommendations for your organization. So please do feel free to use that as you run your programs.